Let's begin with the next question. How does reservation promote social justice in India? Reservation promotes social justice by empowerment and by representation or by redressing inequalities and providing inclusive growth. Let's look at each point. Empowerment. Providing access to education, employment opportunities for marginalized groups. Representation. Ensuring participation of underrepresented communities in governance and decision making. Third is redressing inequalities, that is, addressing centuries of discrimination and exclusion faced by SCs, STs, and OBCs. Fourth is the inclusive growth, bridging gaps in socio-economic development. For instance, reservations in higher education institutions like IITs and IIMs have enabled upward mobility for disadvantaged communities. So the question was, how does reservation promote social justice in India? This also seems to be a very important question. So the how it helps in social justice is by empowerment, that is educating and creating employment opportunities, by representation, that is in governance and decision making, redressing inequalities of centuries of discrimination, and bridging the socio-economic development by providing inclusive growth. What are the criticisms of reservation system in India? This also can be used, can come in the question paper. Critics argue that emphasis on caste, reservation discrimination, reverse discrimination, implementation gaps, and economic focus. So these are the argument of the critics. That is, this reservation system overemphasizes on the caste or solely focuses on caste-based criteria for reservation, and this kind of reservation will perpetuate or increase the division further. Reverse discrimination, that is, many disadvantaged unreserved categories are facing disadvantage in terms of reservation. See, the other groups, the open categories and the other unreserved categories are facing disadvantage because of the reservation system. Another is that the implementation of the reservation system is not reaching the poorest of the poor or the deserving groups. So the benefits are not reaching the deserving individuals due to either corruption or misuse. Another factor is the economic focus. Some critics, they argue that reservation based on economic backwardness rather than caste should be the criteria. That is, not the caste but how backward economically, financially the group is. That should be the criteria. So this is the criticism for reservation system. For example, debates persist over whether creamy layer exclusions effectively target the truly needed. We will look at the creamy layer, not now, later on. What is the Uniform Civil Code, UCC, and what is its constitutional basis? The UCC refers to a common set of laws governing personal matters like marriage, divorce, inheritance, and adoption, replacing religion-specific laws, that is, personal laws. Its constitutional basis lies in Article 44, which is the DPSP advocating for a UCC to promote national integration and gender justice. So this is where UCC is getting its power from. That is from Constitution Article 44 of the DPSP. That is Directive Principle of State Policy. The UCC is also getting its power from the preamble, which emphasizes equality, justice, fraternity, aligning with the goals of a UCC. For example, Goa operates under the Uniform Civil Code like system, applying uniform family laws regardless of religion. Why is the implementation of the UCC controversial in India? The UCC faces resistance due to cultural diversity, political sensitivity, lack of consensus, gender justice versus religious freedom. Let's take a look at each point. So, the argument against UCC is that it directly attacks the religious and the cultural practices of different groups, different religions. So, this is one of the reasons why the implementation has not succeeded yet, because it's directly attacking the religious and cultural practices. Second is, there is a lot of opposition from religious groups who fear that implementation of the UCC will lead to loss of their identity, their culture, their practices, their customs. That is another reason. Next is, there is no consensus, there is no one opinion on what the meaning of uniformity would mean. The preamble of the constitution talks about secularism, which means that all communities, all religions will have equality before the law, before the state. There will be no discrimination based on religion. So here the critics argue that uniformity is very subjective. Next is balancing women's right with religious customs. This is also one of the contentious issue for the implementation of the UCC. For instance, Muslim personal laws on triple talaq and polygamy have sparked debates about reform versus uniformity. How does the UCC aim to achieve gender justice? The aim is to eliminate discriminatory practice first, ensuring equality, standardizing laws, and promoting women's rights. Let's look at each point. The personal laws are based on very old customs. They do not provide equitable provisions. So, to achieve that equality which is enshrined in the constitution, the principle of eliminating discrimination or discriminatory practice is the aim of UCC, to provide common laws for all citizens of India regardless of their religion. This is one of the basic aim of UCC. Ensuring equality, providing equal rights to both the man and the woman, whether in marriage, divorce or inheritance. That is another aim, to provide equality. Then to remove any disparities or differences between different religious communities. That is another aim. Fourth is to protect women's right against practices like dowry and child marriage. For example, codifying a uniform law on divorce could prevent arbitrary practices like instant triple talaq, talaq-e-biddat. Now that has been abolished. It is illegal now to give a triple talaq. What challenges arise in implementing the UCC nationwide? This is very similar to the question that we have just covered earlier. So the challenges include resistance from the religious groups that we already discussed, that communities fear that they will lose their cultural and religious identities. There are a lot of political hindrances or hurdles. Politicians do not fear losing their vote bank. So it's a vote bank politics basically. And they don't want to come out with any contentious reforms or reforms which will go against their vote bank. Again, finding a middle ground between one size fits all laws and respecting diversity. So basically, you cannot have a law. Basically, religion is very personal, and one law for all would not fit in India, and it basically does not respect the cultural diversity. Public awareness. Educating citizens about the benefits and necessity of a UCC has not progressed anywhere. So there is no public awareness of this. the benefits of UCC. For instance, opposition from minority groups has stalled all attempts to introduce UCC at the national level. Next, how do reservation and the UCC reflect the Indian Constitution's vision of equality? Both provisions aim to uphold equality but approach it differently. Reservation basically is focusing on substantive equality by addressing historical disadvantages. That is, those people who have been wronged from ages, for them, reservation is there so they can come up in the social strata. UCC basically is aiming to promote formal equality. That one, reservation is substantive equality. UCC is formal equality by ensuring uniform treatment across religions and communities. UCC is more towards equality of religion and community, whereas reservation is more equality towards historically disadvantaged people like SCs, STs. Together, they reflect the Constitution's commitment to social justice, inclusivity, and non-discrimination. Next, what role does judicial activism play in advancing reservation and the UCC? Judicial activism has been instrumental. Now, what is judicial activism? That pre-active initiation by the judiciary in addressing social inequalities or social issues. Judicial activism has been instrumental in reservation and UCC. We'll look at other ones. Reservation basically means expanding reservations through landmark judgments like Indira Swani versus Union of India 1992, which upheld OBC reservations but introduced the creamy layer concept. UCC, courts have urged governments to implement UCC as seen in Shah Banu Begum versus Muhammad Ahmad Khan 1985. This is also a very important case law where the Supreme Court highlighted the need for gender just laws. For example, the judiciary often intervenes to ensure compliance with constitutional principles despite political reluctance. Next, how can the UCC coexist with India's cultural diversity? This is also a very good question, may not come in the exam, but to understand how it gels with, if it gels, that is, or coexist with the cultural diversity of India. First of all, incorporating flexibility, allowing optional provisions that respect cultural practices without violating fundamental rights. Now, how that would be incorporated is the thing to see. Engaging stakeholders, consulting religious leaders, scholars, and civil society to design inclusive laws. This also would not work, although even if government engages in discussion with the different religious leaders, there would still be a lot of disagreements. Gradual implementation, introducing reforms incrementally to minimize backlash. This too seems to be difficult. So this question overall does not make sense, although these things could have been done by the government to gradually introduce reforms. Whenever there is sudden influx or sudden introduction of laws which are contradictory to the customs being followed from centuries, there will be definitely a lot of backlash and hesitation to adapt to these new laws. Focusing on common ground, prioritizing areas like marriage, divorce, and inheritance where uniformity is feasible. This is, of course, the fourth point is very much acceptable, very much to be implemented. Through this, at least it can be implemented that the marriage, divorce, and inheritance laws can have some kind of uniformity so that it is more feasible. For instance, starting with simpler reforms like codifying inheritance laws could pave the way for broader acceptance. Yes, this is acceptable. Let's move on to the next one. What is the Internet and Jurisdiction Policy Network, IJPN, and why is it significant. We have already covered all of these topics under the shorter earlier first part of the video. The Internet and Jurisdiction Policy Network, IJPN, is a global multi-stakeholder organization that addresses legal and policy challenges arising from cross-border Internet governance. Its significance lies in harmonizing laws, addressing cyber issues, multi-stakeholder approach, and okay, let's look at all the three parts at one at a time. So basically, what IJPN does is it facilitates cooperation between countries or organizations to resolve conflicts which will arise through cyber security issues or through use of internet across the jurisdiction. Second is addressing the cyber issues. Cyber means internet related issues, or tackling issues like data privacy or cyber security or intellectual property or content regulation. This is all addressed by IJPN, which is Internet and Jurisdiction Policy Network Authority. So it will help resolve disputes between governments by involving them into a discussion, also private discussion between the private entities and civil societies, or taking expert technical advice to develop balanced solutions for any dispute that may arise. So three things that IJPN does. So it helps basically to harmonize laws across jurisdiction. It will help address different cyber related issue, which would include your data privacy or cyber security or intellectual property, as well as content regulation. Also, it communicates and involves governments, private entities, and so on, and takes help of technical experts for finding solutions to different disputes. For example, IJPN helps determine which country's law will apply when some kind of online crime would occur across multiple nations or multiple jurisdictions, and that will ensure accountability without stifling or creating a bottleneck for innovation. Next, how has the internet impacted traditional notions of jurisdiction? The internet has blurred traditional jurisdictional boundaries. If there is a country would have a jurisdictional boundary, but internet has no jurisdictional boundary. Global reach. Online activities have transcended national borders, of course, complicating enforcement of local laws. So if there are certain local laws and that has to be applied, like for example, Information Technology Act, how would you employ certain acts, certain regulations which have arisen from across the border? Of course, there are a lot of challenges in enforcement, which means that how do you determine which court will have authority over the issues or the disputes which have arisen between different parties across different countries. So that also is one of the challenges in enforcement. Third is the emerging technology and the framework. So international treaties and frameworks like GDPR, which is General Data Protection Regulation, which is used or which is in use in Europe, aims to establish clear guidelines for jurisdiction in cyberspace. So these are one of the regulations, General Data Protection, GDR or GDPR. For instance, a defamation case involving social media posts may raise questions about whether the plaintiff's location or the server's location determines jurisdiction. So this is resolved by IJPN. Next, what is social media and how has it transformed communication? Social media refers to digital platforms like Facebook, Twitter, Instagram that enable users to create, share, and interact with content. It has transformed communication by instant connectivity. Social media has there's a lot of advantages of social media in terms of instant connectivity, where it allows real-time interaction or communication across the globe through Zoom, through Google Meet, and there are a lot of other mediums, WhatsApp, and so on, where you can have instant connectivity. It helps in amplifying voices, that is, the marginalized people or people who have been wronged over the centuries can easily voice their opinion on social media and express themselves and thus reach a vast audience, facilitating movements. Of course, the campaigns and public discourse like Black Lives Matter, Me Too movement, these have helped in increasing the voices of women and marginalized people, especially Black Lives Matter. In the case of Derek Chauvin and George Floyd case that we studied earlier, in which the Black Lives Matter case was initiated. Now, Me Too movement is also there, but we'll cover that later. Business engagement helps companies connect directly with customers. So this is also we have LinkedIn, and there are many platforms across available. So this is what social media does. However, there are a lot of concerns as there are advantages to social media like spreading of misinformation or cyberbullying, cyber targeting, or privacy violations, hacking, phishing, and so many things are there. How does social media influence freedom of speech and expression? This is covered under Article 21A, no, rather 19A, 191A, freedom of speech and expression. That was right to speech and liberty. Was it? I'll have to check that out. Social media serves as a powerful tool for exercising freedom of speech and expression under Article 19(1)(a). Freedom of speech and expression under Article 19(1)(a) of the Indian Constitution. However, let's look at the influence, how social media has influenced freedom of speech and expression. Positive, negative aspect. So we'll look at both. So basically, positive aspect of the social media as far as the freedom of speech and expression is concerned is that it helps amplify voices of the marginalized people. It promotes transparency and fosters dialogue. The negative aspect is again the hate speech, fake news, trolling. Often these test the limits of free expression. Legal safeguards. Laws like 66A, Section 66A of the IT Act, which was struck down in Shreya Singhal versus Union of India, and other provisions regulate misuse while balancing free speech rights. For example, while social media empowers activists, governments sometimes impose restrictions citing national security or public order. Next, what are the challenges of regulating freedom of speech on social media? The key challenges include balancing rights, content moderation, accountability, and global standards. Let's look at each of these challenges for regulating freedom of speech and expression on social media. So, what kind of challenges are we facing on the social media as far as Article 19(1)(a) is concerned? So, the challenge is in ensuring how do you control free expression while also curbing or stopping the harmful content like hate speech or misinformation. So this is one of the challenges of 19(1)(a), that is freedom of speech and expression. How does one understand? How does one constitute, or what is the acceptable speech without bias? That is, what constitutes an acceptable or not acceptable content? So that is the content moderation. How do we decide what is actually freedom of speech and at what level it bypasses the freedom of speech and expression? Accountability. Who is to be held accountable? the user or the platform, uh, because the platforms are basically just a medium through which the user generates content. So how do we account for this of regulating of freedom of speech? Next is aligning the regulations. How do you align regulations across jurisdictions with differing cultural norms? That is another challenge for regulating the freedom of speech on social media. For instance, debates arise over whether platforms should remove controversial political content or allow open discussion. So, how do governments regulate social media platforms? Let's look into this. This is an important question, and it will keep happening and increasing as governments try to control more and more on the social media. Governments regulate social media through Information Technology Act or IT rules of 2021, mandating due diligence by the intermediaries. That is, the ISPs and other social media platforms have to do their own due diligence and uh, create a kind of policies to stop uh, uh, hate speech and misinformation and so on. So that legislation, are like IT rules and Information Technology Act has come out, has been enacted by the legislation. Content takedown orders. Governments can direct social media platforms or any kind of platform, Twitter, Instagram, and so on, to remove any unlawful or harmful content which will spread discontent among the society. Government also requires that all user data which is generated within India has to be stored within the national border. So this is how the government is regulating social media. So data cannot be sent out of India. The data which has been generated in India, the user data of India has to be within India. And there are many platforms which have refused to adhere to this dictate of the government. That is the data localization, the transparency reports, that is mandating disclosures about content removals and government requests, that is to uh, disclose if government requires certain, if there is a government request to remove certain posts which are objectionable, then that has to be removed. So there is a transparency. So how does government regulate? Through legislation, through content takedown order, that is to remove the content through their orders, data localization, that is to keep the data within the country, and reports of the removals that government has requested. For example, India's IT rules require social media companies to appoint grievance officers. Yes, very important. And comply with takedown notices within stipulated timelines. I think it's around 3 days or so. What role does social media play in shaping public opinion? Social media plays a pivotal role in shaping public opinion by, that is how, the question itself is very important. It says that how opinion of the people is shaped by social media platforms. So we know how Facebook, YouTube, Instagrams, they are influencing and shaping the opinion of the public. So they are pivotal. They are playing a very pivotal role, very important role in shaping public opinion. The four ways that it does is by disseminating information, that is spreading or sharing of information. So spreading news, opinions, and ideas rapidly. Earlier, through TV and newspaper, it was once in a day, or maybe slightly more, maybe twice a day. But nowadays, through social media platform, it's instant. Influencing perceptions. So social media algorithms and curated, that is content which is very specific to a specific target audience. which is referred to a specific target audience, are basically influencing the way people think or perceive the social environment, that is that the political environment, social and economic environment. So it is easily manipulated through algorithms. Also, mobilizing movements. Social media can increase the basically people, the political parties and groups can generate support for their cause or protest. For example, we have seen in India farmers protest, in which social media was used to rally support for the movement. Arab Spring is another. Echo chambers. This basically reinforces the bias of the people by exposing users to like-minded views. So they are again and again targeted with the same content, and therefore it shapes their opinion. So basically, it's an echo chamber. You are hearing yourself again and again through the because the algorithms are targeting what you want to see. So they are pushing you the content which you like, and thus increasing your one-sidedness or your biases. For instance, viral hashtags can sway public sentiment on issues like climate change or human rights. Next, how does social media impact democracy and governance? Social media impacts democracy and governance in both positive and negative ways. So this is how the social media impacts democracy and governance. The positive impact is that it enhances citizens' participation through awareness campaigns and petitions, holds leader accountable via real-time updates and scrutiny. There are many more benefits for governance, at least. This we are looking for democracy, but for governance, nowadays you can file your income tax online. There are a lot of authentications that you can do. Online banking is there. Then OTP authentications are there, and so many things are there which can be done. So those are all positive impacts of social media. Of course, the one that I'm talking about is more towards digital signature certificate or electronic signatures and all of that. But here, as far as the governance is concerned, this basically the citizens can communicate or interact with the government and can file their campaigns or interact with the government officials. More and more information is being shared with the public by the authorities. Negative impacts. Basically, social media can spread misinformation or hate speech and so on, undermining informed decision making. It enables manipulation through fake accounts or robots, basically bots in short, during elections. For example, Cambridge Analytica misuse of Facebook data highlighted risks to electoral integrity. What ethical considerations arise with social media use? For example, when so we use social media, the ethical consideration that needs to be considered is one, privacy violation, unauthorized use of personal data for targeted or advertising or surveillance, that which is happening nowadays. So all companies, Google, Facebook, they are using our data. So they are violating our privacy rights. But then we have also agreed to their terms and conditions. So that is how it is. Although they may not be sharing the data, which is which can be doubted, but since we have given them our consent, they can use that data for advertising and surveillance. Misinformation. Spreading of false information leads to panic or harm. This is the ethical consideration that we are looking into. Cyberbullying, which is harassment and abuse, which affects mental health. Addiction, overuse impacts productivity and well-being. This is all of us can relate to it. Hours of spending on YouTube or Facebook or Instagram and all of that. We are constantly scrolling through for hours together. So basically, it's a kind of an addiction. For instance, debates persist over whether platforms should prioritize profit over user safety and societal welfare. Children's health is also affecting. Our concentration level in our studies is decreasing because of using shorts, YouTube shorts, and short form of content, basically. How can individuals responsibly use social media? Individuals can use social media responsibly by verifying information, that is cross-checking facts before sharing content, which mostly nobody does. Nobody has bothered to do it, and most of the people don't have time also to cross-check the facts before sharing the content further. So they would share WhatsApp messages and so on without verifying it. Respecting privacy, avoiding unauthorized sharing of others' personal information is also important. Many people are sharing unauthorized or they're not authorized to share the information, yet they do. Engaging constructively, participating in meaningful discussions rather than spreading negativity. Reporting abuse, flagging inappropriate content or behavior to platform moderators. For example, promoting credible sources during crisis helps combat misinformation effectively. So we were studying of how individuals can responsibly use social media. What is artificial intelligence and how it is being used and integrated into the legal profession? Artificial intelligence refers to a systems or machines that mimic human intelligence to perform tasks such as learning, reasoning, problem solving. In legal profession, AI is being integrated in various ways. Let's see. 4 ways: legal research, document automation, predictive analytics, and e-discovery. Let's look at each point. Tools like Ross Intelligence and LexisNexis, they use AI to analyze case laws, statutes, and legal precedents quickly. Document automation, drafting contracts, petitions, and other legal documents using AI-powered software. Predictive analytics, forecasting case outcomes based on historical data and judicial trends. This is predictive analytics. E-discovery, reviewing large volumes of evidence efficiently during litigation. For example, AI can scan thousands of documents in minutes, identifying relevant information for a case. So AI is very, very useful for our future law practice. How does AI enhance efficiency in the legal profession? Okay, so AI enhances efficiency by speed. Speed, we get accuracy, cost saving, and scalability. So let's look at speed. Automating repetitive tasks like document review and research saves time. We can find out grammatical errors, sentence errors, or logical errors. We can even tell the AI to tell us what are the problematic issues or what issues it can detect in a legal document. So this will save us time in finding out the contentious issues or repetitive issues. If there are very repetitive, we can tell it to enhance also. Accuracy, reducing human errors in analyzing complex data or drafting agreements. For example, we can tell AI to find conflicting data in our at one place. For example, it may be written that the contract is valid for 30 days. At another clause, it may have been written that the contract may be valid for 60 days. So it's conflicting. So AI will let us know where the conflicting clauses are. Cost saving, lowering operational costs for law firms and clients through automation. This is much speedier. So basically, instead of spending hours and hours reviewing the document, the AI can go through within 1 minute and show us all the problems that are there in the legal document. Scalability, handling large scale projects like due diligence and compliance audits effortlessly. So even if the case papers are running into thousands of pages, which will require weeks and weeks of scrutiny, the AI can do it within few minutes. For instance, AI tool can extract key clauses from dozens of contracts within seconds, enabling lawyers to focus on strategy. What are the potential risks of AI in legal profession? While AI offers numerous benefits, it also poses risks. The risks are biases in algorithms, which we all know how it affects the social media users. AI systems may perpetuate or increase and enhance the existing biases, the opinions, one-sided opinion, if the data itself is trained on skewed or misrepresented data sets or one-sided data sets. Also, AI in legal profession would lead to job displacement. Automation could reduce demand for junior lawyers handling routine tasks. Ethical concerns. Questions arise about accountability when AI makes errors or unethical decisions. So that is one of the key questions. Plus, what about the privacy of the data? Over reliance, dependence on AI might undermine critical thinking and judgment skills, which we are nowadays seeing that more and more reliance is being put on AI. People are generating more and more content through AI than their own notes. For example, an AI system recommending sentencing guidelines could inadvertently favor certain demographics over others. Next, will AI replace lawyers in the future? The answer is no. AI will not replace, but they will augment their roles. That is, they will help in increasing the efficiency of the law profession. Augmentation over replacement. AI handles repetitive tasks, allowing lawyers to focus on complex strategic work. Creativity, empathy, and nuanced decision making remain irreplaceable in areas like negotiation and advocacy. Collaboration. The future lies in human AI collaboration, where technology complements professional expertise. For instance, while AI can draft a contract, a lawyer is still needed to negotiate terms and ensure alignment with client goals. Next, how can AI assist in legal research and analysis? AI transforms legal research and analysis by NLP, that is the natural language processing, which basically understands queries and retrieves relevant case laws and statutes. So this is how AI is helping in legal research and analysis by retrieving the case laws and statutes based on the user query. So we'll give some queries and it will retrieve the case laws and the relevant statutes. It analyzes patterns, trends in judicial decisions, and it can also predict what kind of an outcome we can expect. Another advantage in AI being used in legal research is basically condensing or summarizing lengthy judgments into concise summaries that we can understand quickly. So we don't need to read through pages and pages of judgment. Instead, we can tell the AI to summarize the judgment. Also, cross-referencing, that is linking with related cases or finding regulations that are applicable to our cases, that all can be done through, and also gathering scholarly articles very easily. All of these help in gathering the documents. Next is, how can AI improve access to justice? AI can improve access to justice by affordable services, by self-help tools, by pro bono assistance, and by remote access. So we are trying to understand how AI improves access to justice. So affordable service, reducing the cost for clients through automated processes. Self-help tools, providing chatbots or apps to guide individuals through legal procedures. This may happen in the future, both the first and the second point. Pro bono assistance, enabling NGOs to scale their efforts using AI for case management. This too will be happening in the future, very soon in the future. Remote access, facilitating online dispute resolution and virtual consultations. This is right now going on, the fourth point. So all of these things are helping uh, 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 faster or easy access to justice through the use of AI. For example, AI driven platforms like Do Not Pay help users contest parking tickets or file small claims without hiring a lawyer. Oh, I was not aware of this, that we have a option of not paying our parking tickets. I'm not sure whether this is for India or somewhere else. That we can check out later. Question number 8. What skills should lawyer develop to adapt to AI driven changes? Lawyers should develop skills such as tech literacy, data analysis, critical thinking, adaptability. So we are looking at these the skills that lawyers should develop so that they can adapt to the artificial intelligence driven changes. So they are tech literacy, that is understanding how these AI tools function and also how to use them in their day-to-day work. Data analysis. A lawyer should be able to interpret and get insights into how the AI systems are effectively generating case laws or their analysis. So they should be able to interpret the whatever the output is generated by the AI system. Next is critical thinking. That is, the lawyer should be able to evaluate the output generated by AI, uh, and that evaluation should be of critical nature. One should not just accept whatever output is generated by AI rather than just accepting them blindly. That is what I mentioned. Adaptability. One has to stay updated on emerging technologies and how they are used or how they are applied in law. For instance, mastering e-discovery software enhances a lawyer's ability to handle large scale litigation efficiently. So all of these tools one can study: e-discovery and the for contesting the parking tickets and so on. Next, how does AI impact the role of judges and courts? AI impacts judges and courts by one, case management; second, decision support; third, sentencing guidelines; and fourth, virtual hearings. So let's look at how artificial intelligence is helping judges and courts. First, streamlining dockets and reducing backlogs through predictive analytics. Second is offering insights into similar past cases to aid consistent ruling. This is very important. Second point. I'm not sure how much of this is now, as of now, applicable in Indian courts or how much of this is being used. Third is providing data driven recommendations for fairer outcomes, enhancing accessibility through AI powered transcription and translation services. So, for example, artificial intelligence systems can flag or can show inconsistencies in sentencing patterns, ensuring equitable treatment across cases. What does the future hold for AI in legal profession? The future of artificial intelligence in the legal profession includes advanced automation, global collaboration, regulatory framework, and personalized legal services. So we are learning about the future of AI in legal profession. So AI can handle more complex tasks like contract negotiation and risk assessment in the future. We are trying to understand how it will help us in the future. Now, any cross-border legal work can be easily facilitated through unified AI platforms. That is, they will help us enhance and understand clearly any cross-border legal disputes, because each country would have a different legal framework. Next, developing ethical guidelines and standards for AI usage in law, and tailoring advice and solutions to individual client needs using AI. The fourth point would be definitely very important, because as the workload increases, we can take help of AI, so that the advice given by the AI and the solution would meet individual client needs. For instance, blockchain integrated AI system could revolutionize intellectual property rights management globally. What are virtual courts and how do they function in India? So, virtual courts are online platforms where judicial proceedings occur without physical presence. So, virtual courts are nothing but online courts, or appearing in the court through medium of video, audio video medium. So, there is no need for physical presence or physical appearance. So, they function in India. These virtual courts, they function through video conferencing, digital filing systems, and secure portals. So in video conferencing tools, judges, lawyers, and litigants participate remotely, which is very frequently happening nowadays. A digital filing system, documents and evidence are nowadays submitted electronically. Secure portals, access to case updates, judgments, and filing is nowadays available very easily through eCourt, which is also available on the mobile app. Introduced during the COVID-19 pandemic, virtual courts ensure access to justice while maintaining safety and reducing delays. Next, what are the advantages of virtual courts in India? The advantages include cost efficiency, that is, it reduces travel expenses for litigants and lawyers. That is one advantage of virtual court. It saves time. It's accessible, easily accessible from remote areas also. And there is environmental benefits in terms of reduction of paper usage and commuting. So these are very basic and common sense answers. Let's move now to the next question. What challenges do virtual courts face in India? We are looking at the challenges faced by the virtual courts. First of all, digital divide, infrastructure gaps, cybersecurity risks, and resistance to change. Now, digital divide means that not everybody has access to internet, and even the literacy rate of using technology and how to access the virtual courts. All of that is a kind of a challenge. Another is the infrastructure gaps, which is insufficient hardware and software capacity, as well as the internet bandwidth. That is, slowing down of the internet may cause disruption in the court proceedings. Next is the cybersecurity risks. The virtual courts are vulnerable to hacking or data breaches during online proceedings. So this also is one of the challenge. And of course, the stakeholders, the judges, the lawyers, they may prefer traditional methods over appearing in instead of digital ones. For instance, senior lawyers and litigants unfamiliar with technology may struggle to adapt to virtual court systems. Next, what is eCourt project? eCourts project in India, and what are its objectives? Now, what are the objectives? Basically, to digitize, that is, all the court records and processes can be digitized or has to be digitized. That is, it has to be converted into electronic form for record keeping and electronic filing. Also, to provide real-time case status updates. Now, this is easily available nowadays. If we have a case, if we have 10 cases, we can see on which date it is through eCourt software, online software. So the eCourts, one of the objectives to provide the real-time case status updates, which will help litigants to track their cases online, enhance transparency and efficiency in terms of reduced backlogs and improving the case management, and promote paperless courts, which of course minimizes the reliance on physical documents. How has virtual courts contributed to reducing case backlogs in India? Let's understand this. This is a very important question. Virtual courts help reduce backlogs by first conducting hearings for minor offenses, which means resolving cases like traffic violation and petty crimes quickly through online medium, minimizing adjournments, avoiding delays caused by logistical issues. For example, if one of the parties advocates is not able to appear in the court, then the case gets adjourned. Instead of doing that, the person can appear online, not citing logistical issues. For example, flight delay or train delay or whatever. Though all those excuses which were earlier used by advocates to extend or take dates upon dates. Next is prioritizing urgent cases. Uh, fast track fast tracking matters requiring immediate attention through scheduling and encouraging settlements, promoting online mediation and arbitration. These are alternate dispute resolution, also known as ADRs. These are mechanisms through which one can opt to resolve matters out of the court through ADR mechanism or through mediation. For example, virtual courts resolved thousands of pending cases during the pandemic, easing pressure on the judiciary. Next, how does the e-courts project address transparency and accountability? The e-courts project enhances transparency and accountability by first allowing public access to information. That is, public would have more access to information like their case details, orders, judgments. These are all accessible online nowadays. Now, real-time monitoring. The litigants and lawyers can track their case progress as well as timelines or the next date of hearing and so on. Reduced human intervention. Basically, e-courts minimizes opportunities for corruption or manipulation, which was apparent and used during the manual process. So there was a lot of manipulation happening when everything was happening manually. Data analytics, using AI to identify trends, inefficiencies, and areas needing reforms. So AI is also helping in improving the e-court project. For instance, e-courts services app provides real-time updates on the status of the case, hearing dates, fostering trust in the system. Next, what role does technology play in ensuring accessibility in virtual courts? So basically, how is technology helping the virtual courts? First, anybody can participate through remote, through use from remote place. That is, then it also supports multilingual support. There's a support for multiple languages. There is an assistive technologies for people who are visually impaired, who cannot see. These assistive technologies will read out the text on the screen. Mobile applications, they provide access to the court services via smartphones, even in remote areas. So this is how technology is helping the virtual courts. First, by allowing remote participation. Second, by supporting multi-language options. Third is helping able to read through assistive technologies and mobile applications for accessing the e-court services. Next, how does the integration of AI benefit virtual courts and e-courts? So the question is the benefits of AI in virtual courts and e-courts. First, it will help, the AI would help automate routine tasks, that is, drafting of notice, generating case summaries, or managing dockets. So, in all of these, the AI can be very beneficial. Second is the predictive analytics, that is, forecasting the case outcomes based on historical data to aid decision making. Now, AI can help look at thousands of past cases of similar nature. If some query is given for the current case, it can give the judge an outlook or a forecast as to what should be the likely outcome. Fraud detection, identifying discrepancies or irregularities in filings and evidence. This can also easily be detected by AI. Enhanced security, protecting sensitive data using encryption and biometric authentication. So if somebody wants to log in to e-courts, they can do that through biometric authentication, or even sensitive information can be protected using AI technologies. Next, what steps is the Indian judiciary taking to overcome challenges in virtual courts? So the judiciary is addressing these challenges that India is facing in virtual courts is by increasing the infrastructure development, that is upgrading the courts facility with high speed internet and video conferencing too. Training programs, conducting workshops for judges, lawyers, and staff on how to use these digital platforms. Of course, educating the litigants about virtual court procedures and benefits, and also introducing guidelines for cybersecurity, data privacy, and ethical use of technology. For example, the Supreme Court's guidelines for court functioning through video conferencing standardizes practices across jurisdiction. That is what is the guideline when one is to connect through video conferencing. So they have come out with guidelines. What is the future of virtual courts and e-courts in India? The future includes, this is what I also wanted to know, where we are going with the virtual courts and e-courts. First of all, we still have hybrid models, which means we have still combining virtual and physical hearings for flexibility. People who want to be heard, who are used to being heard in the court, they can visit courts. Otherwise, if they are at a far away remote place, they can connect through the virtual court or virtual video conferencing. Advanced technologies like integrating artificial intelligence, blockchain, and cloud computing for enhancing the efficiency of the virtual courts and e-courts. Bridging the digital divide. These were also drawbacks, so we can convert it into positive aspect also, that bridging the digital divide through affordable devices and internet connectivity. So more people can connect, more ease of access. Global collaboration, sharing the best practices with the international judicial systems. That is, what are judicial systems abroad in other countries, what best practices are they following, and to implement that in India, and to refine it in the virtual court framework. For instance, blockchain could ensure tamper-proof record keeping, while AI chatbots might assist litigants with procedural queries. So this is a very good, I see it being very nice and good initiative of integrating AI in the judicial system. So this completes the very long video of, I'm not sure, maybe 4-5 hours on legal language semester 2, first year BA LLB, Mumbai University. I hope you would listen through till the end, and if you have any queries, questions, do put it into comment section. If it has helped you, do share, subscribe, like the video if you want to, and share it. Of course, share it with your friends so they can also benefit. Thank you very much for staying all the way through. Take care. Bye bye.